You're going to hear, first of all, from something of a rising star at the Bristol Bar, Natasha Dzameh, who's going to talk about both constructive trusts and proprietary estoppels. And as all practitioners know, these are two interlinked topics and grounds of relief, where members of the public, practitioners, and indeed judges don't know the differences between the two of them. Hopefully those are going to be fully explained for you. Natasha is a property and commercial practitioner, dealing with, amongst other things, commercial property. She's been the Bristol Barrister of the Year, and she has an excellent and burgeoning reputation, both in the dictionaries, in the various books, and also in Chambers Legal 500, places like that. So with that short introduction, I'm going to leave it to Natasha to get rid of my face off the screen, put up the slides, and tell us about constructive trusts and proprietary estoppel. So over to you, Natasha.
I'll be arranging to transfer my bribe to Leslie after this webinar for that introduction. So cracking on with this topic then, which is constructive trusts and proprietary estoppel, what I'm going to do is take you through the basics really of these two areas and just outline at the end the reasons why you might want to choose one over the other, or why you might want to plead one as your primary position and the other as your secondary. So if we start with constructive trusts, really on the constructive trust front, I'm going to be focusing on the domestic consumer context, because that's generally the kind of situation that you've got when you're looking at the two together. So the first thing that you've got to think about in relation to constructive trusts and the beneficial interest in a property is whether there is an express declaration. And if you do have an express declaration, that's going to be conclusive as to the beneficial interest in the property, unless it can be set aside, and there are limited grounds upon which you can set an express declaration aside, for example, mistake, fraud, undue influence, or it may well be affected by a subsequent agreement or by proprietary estoppel. Now, in relation to an express declaration, because it's a declaration of trust, it needs to satisfy the three certainties. So that's your certainty of words, subject matter, and objects or beneficiaries. You need to also have a look at sections 52 and 53 of the Law of Property Act 1925 and section 1, subsection 2 of the Law of Property Miscellaneous Provisions Act 1989, but I'm not going to take you through all of those. One point that I would flag is this issue of there being a subsequent agreement. Now, it doesn't strictly say a subsequent written agreement, but because of the requirements of those sections, that's generally expected to be the case. But there was an interesting point raised in Clark and Remedies, and this was I think it was a strikeout application that was being heard. And so there was a case that was being put where there were express declarations of trust, but there were arguments being put as to proprietary estoppel and alternatively a remedial constructive trust. Now, realistically, insofar as English law is concerned, it's very much set against remedial constructive trusts. We do have what are referred to as institutional constructive trusts, but you tend to find those arising in quite limited insolvency situations. And so there's something of a debate over the extent to which institutional constructive trusts are different to remedial constructive trusts. But the judge in that case noted that English law is very much set against the idea of remedial constructive trusts, albeit the attitude of the courts may somewhat be changing in his view. Now, he'd considered that if Clark could have established that a remedial constructive trust was available in the circumstances as a remedy in English law, then obviously that constructive trust claim shouldn't be struck out. And in his view, Stack and the other authorities didn't preclude such an argument, but obviously the issue that precludes it is simply that the courts failed to recognise the existence of those types of trusts in this context. Now, constructive trusts are effectively an equitable remedy that prevents unjust enrichment resulting from unconscionable conduct or fraud. And so as I've mentioned domestic consumer context, the natural question that arises is, well, what do you mean by the domestic consumer context? And generally what you're talking about there is a quasi-matrimonial home purchase. So effectively you have parties who are oftentimes in a relationship and they have purchased a home to reside in together, rather than it being a property that they've acquired as an investment. But that's not always the case. So an interesting case to have a look at is Roland and Blades. And so in that case, it was an unmarried couple in their 50s, and they began a relationship in 2006. Now, they'd purchased the property as a holiday home and a weekend home in March 2009, and it was conveyed into joint names. So this wasn't a property that they purchased to reside in together as a quasi-matrimonial home. Now, Roland had funded the entire purchase, which was around £1.5 million, and had paid all of the costs that were associated with the acquisition. They each had their own properties separate to this property. They had separate bank accounts, and they never, in fact, pooled their resources. Now, shortly afterwards, the relationship began to break down when Roland, in fact, started to see another woman. And Roland contended that the property was purchased on the basis that it would be entirely his, or alternatively, that it subsequently became entirely his. Now, the relationship had broken down in the latter part of 2009, so not that long actually after the purchase. But there were times when the parties did in fact rekindle their relationship after this, and there were occasions when they both spent time at the property together. And the judge recognised that this case was clearly not on all fours with the typical domestic case. So, for example, the property wasn't purchased as a family home to reside in together. Roland had provided the entire purchase price, and there was no pooling of resources. Now, nonetheless, the court took the view that this was a domestic consumer case because it was more akin to that than a commercial case. But it's notable in that situation that, in fact, both of the barristers had agreed that the case should be approached as a domestic consumer one. So you may well take with a pinch of salt the idea that this was viewed as a domestic consumer case because both of the barristers had fundamentally put forward their cases on the basis that it was such a context. So really, it wasn't something that the court was looking at contrary arguments on. Another case on this point is Woodzicki. Now, in that case, the property was registered in the joint names of the late father and his second wife, but it had been exclusively occupied by the father's daughter since the purchase, and he died intestate. Now, the judge had found that the daughter had a life interest in the property and was entitled to occupy it. The judge also determined that the daughter and second wife beneficially owned the property in the proportions to which they had contributed to its purchase, maintenance, and outgoings. And so, in fact, what it did there was to apply a resulting trust analysis. Now, this was ultimately appealed, and one of the grounds being that the court should have applied a common intention constructive trust analysis. Now, the court noted that it was for the daughter to establish initially that she had any interest in the property because it was not in her name. It was effectively a sole name case. And the court determined that the approach applied to cohabiting couples was not appropriate in the circumstances. So this idea of the domestic consumer context didn't apply here. The daughter and her stepmother were not close, and the stepmother would not have intended to make a gift to the daughter. So you'll see from that when you're looking at this idea of the domestic consumer context, it's not quite as straightforward as saying, oh, well, everyone is in some way part of a family, and so that makes it a domestic consumer context case. Now, moving on to my next slide, dealing with this issue of express declarations. So there was a situation where there is no express declaration. So the two main cases on that are Stack and Dowden and Jones and Kernet. And I'm sure you're all aware of the facts of Stack and Dowden, so I won't go through all of that. But there is a useful paragraph in Stack and Dowden to have a look at, which is paragraph 69 of that judgment. And what you have within that paragraph is a list of factors. It's a non-exhaustive list of factors by Baroness Hale as to the various different things that the court should consider when it's attempting to determine the intentions of the parties. Now, I'll just very briefly take you through the facts on Jones. Now, in that case, the parties had purchased the property in joint names in 1985 for £30,000. And Jones had paid the deposit of £6,000, with the balance being raised by way of an endowment mortgage in joint names. And so there was no declaration regarding the beneficial interests. The mortgage and the other household expenses were paid out of joint resources, and they ultimately took out a loan to build an extension, and that loan was taken out jointly. Mr. Kernet did some of the work himself, and ultimately he moved out whilst Miss Jones remained there with their two children. She took on sole responsibility for the outgoings, and he made no further contributions in relation to the acquisition of the property. So in 1995, the property was placed on the market, but it didn't sell. And the parties cashed in a joint life insurance policy and divided the proceeds equally. Mr. Kerner put a deposit on a home of his own that he purchased with a mortgage in 1996. Now, ultimately, the value of the property increases, and so, surprise, surprise, he wants to realise his beneficial interest. Ms. Jones applies for a declaration under Section 14 of Talata that she owns the entire beneficial interest in the property, which was valued at £245,000 in 2008. The judge at first instance held their common intention had changed and relied upon Stack to declare that Mr. Kernet was entitled to only 10%. And the Court of Appeal held the interest to be 50-50, with the Supreme Court determining the shares to be 90-10 in favour of Ms. Jones. The helpful part, in particular, of Jones and Kernet is that you find that in the judgment, there are 5 criteria set out, paragraph 51, that really explain what happens in these situations. And so the starting point is that equity follows the law, and that where you have the property held in joint names, they are joint tenants in law and in equity. Now, that presumption can be displaced by showing either that the parties had a different common intention at the time when they acquired the home, or that they later formed the common intention that their respective shares would change. That common intention is to be deduced objectively from their conduct. So the relevant intention of each party is the intention which was reasonably understood by the other party to be manifested by that party's words or conduct, notwithstanding that he did not consciously formulate that intention in his own mind, or even acted with some different intention which he did not communicate to the other party. Now, in those cases where it's clear either that the parties did not intend a joint tenancy at the outset, or had changed their original intention, but it was not possible to ascertain by direct evidence or by inference what their actual intention was as to the shares in which they would own the property, the answer is that each is entitled to that share which the court considers fair, having regard to the whole course of dealing between them in relation to the property. And ultimately, each case turns on its own facts, and whilst financial contributions are relevant, there are other factors that the court will look at in order to decide what shares were intended. Now, there was some debate in Jones as to whether there was a significant difference between inference and imputation, albeit the majority didn't feel that there was such a difference. That was really dealt with in Barnes and Phillips more substantively. And so ultimately, the position is such that whilst the court can make a decision insofar as determining that, yes, there has been an express agreement reached, or that it can infer that there is an agreement based on conduct, it cannot impute the existence of an agreement. So it can't impute that there was an intention to have a beneficial interest in the property. But once it gets to the point of having either determined that there was an express agreement, or that based on inference, there was such an agreement, it can in fact impute as to the shares that the property is held in. Now, going on to the next slide, just a couple of points that I want to flag to you. So if you have a situation where there is a joint tenancy and that joint tenancy is severed, that will result in a 50-50 split effectively. So severance of a beneficial joint tenancy results in tenancy in common in equal shares, unless, for example, you have an express trust that stipulates otherwise. And so ultimately what the court is seeking to do here with constructive trusts and common intention constructive trusts is to determine the intentions of the parties, whether it's expressed or inferred. Now, there's an interesting point in Stack and Dowden by Lord Neuberger, who states that in many cases, there will, in addition to the contributions, be other relevant evidence as at the time of acquisition. Such evidence would often enable the court to deduce an agreement or understanding amounting to an intention as to the basis on which the beneficial interest would be held. Such an intention may be expressed, although not complying with the requisite formalities, or inferred and must normally be supported by some detriment to justify intervention by equity. Now, this issue of detriment is something of a contentious point, particularly following a case called Hudson and Hathaway. And so in this case, the parties had cohabited for 20 years. They purchased a property in joint names with no declaration of trust. They both accepted that at the time of purchase, they were beneficial joint tenants, and they both worked and paid their salaries into a joint account. Over time, Hudson's earnings exceeded Hathaway's, which resulted in him paying substantially more of the mortgage. And upon separation in 2013, they'd agreed that Hudson would keep his pension and shares in his sole name, with Hathaway having the equity in the house and the bank savings. Now, Hathaway agreed to prepare the house for sale, but there was an insurance claim that had been ongoing since 2011. And that became protracted and caused delay. In 2015, Hudson complained about the time that had passed since their deal and ceased to contribute to the mortgage, so he issued a claim for an order for sale and sought division of the proceeds of sale. Now, Hathaway agreed that the house should be sold, but claimed that she was entitled to the full proceeds under a constructive trust due to the agreement reached as a result of their common intention. Now, at first instance, this was dealt with by His Honour Judge Rolton, and he found that the express agreement was a clear common intention that Hathaway would have the entire interest. So there must be activity resulting in a change of position or detrimental reliance to support a common intention to vary the shares. And he concluded Hathaway had shown the requisite detriments by desisting from making claims against assets in Hudson's sole name, for example, his shares and pension. This was something of a contentious point because it was arguable, at least, that there was no viable claim in respect of these shares and pensions. So really what had been sacrificed, what was the detriment? So this was appealed on one ground to Mr. Justice Kerr. And that was that the judge was wrong to decide sufficient detrimental reliance or change of position on the part of Hathaway that had been made out. And so Hathaway contended that it was unnecessary to show detriment in a joint names domestic consumer context case, or alternatively that there was a valid contract but for want of the necessary formalities, and Hathaway had acted to her detriment in reliance upon this. And further, she paid the mortgage on her own since January 2015 in reliance on her right to the whole equity. Now, her barrister distinguished those cases outside of the domestic consumer context or those involving an express declaration or the sole name of one of the parties on the basis that in those cases, you effectively require a fresh trust to displace the legal title or an express declaration of trust, which, he said, simply isn't the case insofar as these situations before the court. Now, looking at the judgment, the judge noted that none of the Lord Justices in Jones and Kernet had in fact mentioned detriment. It stated that the analysis is not the same as between joint names and sole name cases. So both seek evidence to rebut the presumption that equity follows the law, and the onus is on the party seeking to displace the legal title, with there being a need for a constructive or other trust in order to displace the legal title. But the manner of establishing a constructive trust was not the same. It was said that a constructive trust may be established by whatever evidence is necessary to show it would be unconscionable for the party denying the equitable interest to do so. So there need not be an irrevocable change to the beneficiary's legal position. In a domestic consumer context, an express agreement in respect of beneficial interests, which is not a unilateral oral declaration of trust, such that the putative beneficiary is a mere volunteer, can constitute the necessary detriment or satisfying unconscionability, such that there need be no separate detrimental reliance or a change of position in reliance on the promise. And the judge also went on to consider whether, had detrimental reliance or change of position been necessary, this had in fact occurred, and ultimately upheld the first instance decision on the issue of what constituted detriment. This is an interesting case because it does rather change things insofar as prior to this case, generally the view seemed to be that detriment was definitely required on these cases. And the decision here is obviously contrary to that. So unsurprisingly, this is now off to the Court of Appeal, and as I understand it, will be heard on the 22nd of November. So that's certainly one to keep an eye out for. Going on to the next slide, and then skipping over that slide. So briefly, just a flag, in respect of sole name cases, really what you have are two different limbs. So the first limb is for the court to consider evidence of an express agreement between the parties, and the second is for it to consider whether it's justified in concluding that the parties had the necessary common intention in light of their subsequent conduct. Now, I flagged up a few cases there that you might want to have a look at when you're dealing with sole name situations. We've also very briefly referred to a few investment property cases, just so you can have a look at those to see the difference insofar as the court making that decision as to dealing with those by way of a resulting trust rather than domestic consumer context. Because the court generally will be more inclined to deal with those by way of a resulting trust, even where the relationship is familial, because they are more akin to the commercial context. Moving on to the next slide, we're dealing now with the issue of remedies. Now, when you're dealing with constructive trusts, the remedies aren't an issue of discretion in the same way that they are for proprietary estoppel claims. So if, for example, you're saying there's an agreement as to quantum, or the court can draw an inference as to quantum, and you're saying that the shares are, for example, 60-40. Once you establish the shares 60-40, that's ultimately what the court's going to order. The court isn't going to turn around and say, well, actually, I could order that, but I'm going to give you less for some reason. So there isn't the same level of discretion that you have in a proprietary estoppel claim. Ultimately, the case that you're arguing, that's ultimately what you should receive if you're successful. Now, there's the only elements of, I suppose, some sort of discretion is this idea that if you have a situation where you can establish that there was an agreement as to the parties having an interest in the property, but there was no agreement as to the extent of the interest, then the court has that discretion insofar as inferring or imputing an intention on this particular issue of quantum. There's a useful case to have a look at on that, which is Graham, York and York. And the Court of Appeal clarified that when it's required to do that, and it's required to therefore decide what a party's fair share is, it's not concerned with some form of redistributive justice. Instead, the fair share is decided only by considering the parties' dealings in relation to the property. And there is also no presumed starting point of equality of interests, even in cases involving a substantial financial contribution from a non-owner. So what about proprietary estoppel? We're just going on to the next slide, which is the first slide on proprietary estoppel. So the main case that you're looking at there is Thorner and Major. That establishes that there are three components. Effectively, there needs to be an assurance of sufficient clarity. There needs to be a clear and unequivocal promise. There needs to be reliance on that assurance and detriment as a result of reasonable reliance. Now, it's slightly different in terms of acquiescence-based estoppel, because what you have there is a situation where A, adopts a course of conduct in reliance on a mistaken belief as to his or her rights. B, then knows of A's belief and their own rights, which are inconsistent with A's belief. B, fails to assert its rights against A, and A would suffer a detriment if B were able to enforce its rights against it. Now, very helpfully, we have the case of Davies and Davies, which sets out 9 legal principles that the court's going to have a look at when it comes to these cases. So firstly, in deciding whether an equity has been raised, and if so, how to satisfy it, ultimately that is a retrospective exercise. So what the court does is it takes the moments when the promise falls due to be performed and asks whether in the circumstances that happened, it would be unconscionable for a promise not to be kept either wholly or in part. And so you've got the 3 criteria also dealt with there in terms of Thorner and Major. But you need to be aware that insofar as proprietary estoppel claims are concerned, you can't divide them into watertight compartments. So ultimately, there tends to be something of an overlap. So the quality of the relevant assurance may influence the issue of reliance. The reliance and detriment are often themselves intertwined. And so whether you have a distinct need for a mutual understanding may well depend on how all of the other elements are in fact formulated and understood. Now, detriment doesn't have to consist of simply the expenditure of money or some other quantifiable financial detriment, so long as it's something substantial. So for those of you that deal with this kind of work, you'll be aware of the swathe of farming cases that involve people saying, well, I didn't pursue a career in X because instead I was working on a family farm for very little pay because I was going to inherit either the whole farm or a substantial share of it. Now, the question is ultimately whether, and if so, to what extent it would be unjust or inequitable to allow the person who's given the assurance to go back on it. And that's the essential test of being one of unconscionability. And so the issue of detriment is judged at the moment when the person who's given the assurance seeks to go back on it. So ultimately, what proprietary estoppel tries to do is what is necessary to avoid an unconscionable result. And in deciding how to satisfy any equity, the court has to weigh the detriment that's been suffered by the claimant in reliance on the defendant's assurances against any countervailing benefits that have been enjoyed in consequence of that reliance. Proportionality lies at the heart of the doctrine of proprietary estoppel and permeates its every application. And in particular, there must be proportionality between the remedy and the detriment, which is its purpose to avoid. And this doesn't mean that the court should abandon expectations and seek only to compensate detrimental reliance. But if the expectation is disproportionate to the detriment, the court should satisfy the equity in a more limited way. And so in deciding how to satisfy the equity, the court has to exercise a broad judgmental discretion. I'll come on to that shortly. But if we just skip over to the next slide, which is very short slide, next one after that, very short slide in relation to co-owners. And the only reason I flag this on a separate slide is that I found in a number of cases where I received instructions on things like this, and particularly when I've seen them pleaded, situations where there are co-owners and actually the case that's coming forward from the other side really explains that one person has made representations or has made promises and doesn't actually give any detail as to how it is that the other co-owner is in some way bound. So, for example, were there representations by that co-owner? Is there an issue of agency? What's the authority situation? So ultimately, that is something that you need to make sure that you do deal with, because an assurance that's made by, for example, co-owner A to the claimant can bind co-owner B, but if co-owner B is going to be bound by an estoppel, then the assurance or representation must either have been made by them or made with their authority. So you do need to plead all of that out. Now, in Haverfield and Haverfield, that's an interesting case to look at because actually some of the assurances were made by co-owner B, but they weren't particularly frequent. And co-owner B knew that co-owner A was making assurances, what they meant, and that the claimant was taking them seriously. To the extent that the assurances were made by co-owner A when co-owner B was not present, they were considered to have been made with her authority. And so really what you're looking at there are the arguments concerning authority and agency. Now, finally, dealing with the issue of remedies. The remedies aspect is the thing that makes proprietary estoppel difficult to deal with in terms of advising clients as to the likely outcome insofar as quantum is concerned. Because the court has an incredibly broad discretion. And so whilst it does favour a clean break insofar as it's able to allow this, and it's supposed to do whatever's necessary to avoid an unconscionable outcome, it's somewhat unclear as to what the starting position is. And so in Guy and Guy, it was said that the remedy should be based on expectation rather than the financial value of the detriment. But there are ultimately competing views as to whether the starting position is protection of expectation or not. And so Suggett and Guest indicate that that is the case. There's a difficulty with this in that the logic that one applies to say that that argument is, I suppose, viable or makes sense, insofar as you apply it to an acquiescence situation, is quite different to representation. And so the alternative approach is that there is ultimately no such presumption in favour of making the expectation good, with the relief instead being principally determined by the need for relief to do no more than ensure that A suffers no detriment as a result of his or her reasonable reliance on B, albeit A may suffer some detriment if B can show such an outcome would not shock the conscience of the court. Now, that latter view is supported instead by Davies and Davies and Haverfield. So you'll see what the issue is there. We have courts of appeal authorities that assert different positions. And so what on earth are we meant to do? Well, I'll just take you through Guest in a little bit of detail, because that's a case about shifting expectations. I'm not going to go through the issue of all promises, but I just want to outline some facts in this case. And so in that case, the parents made wills in 1981 under which the respondent and brother would inherit the farm property and the dairy farming business equally. The respondent left school in 1982, worked a minimum of 60 hours per week on the farm for a very low wage, and moved into a cottage on the farm in 1982. Now, in 2014, the relationship between the parties broke down and the parents made new wills, excluding any entitlement for the respondent beyond his right to occupy the cottage. They offered him effectively a farming business tenancy, which he felt unable to accept due to affordability concerns. And so in 2017, they served him with notice to quit, and he brought a proprietary estoppel claim. Now, the court found that the appellants had made assurances over the years to the effect that he would inherit a substantial share of the farm, that he'd reasonably relied on that, and he'd worked hard on the farm for many years for little financial reward. So the unconscionability was such that there was an equity in his favour. Now, there was ultimately a clean break requirement due to the breakdown in family relations. And so 50% of the market value of the dairy farming business and 40% of the value of the farm buildings was to go to the son. The parents appealed and said the judge should have asked what an objective bystander must have thought the owner intended to avoid an unconscionable result. Therefore, a remedy should have been reached based on the increased value of the farm. And they argued alternative remedies were more appropriate, such as compensating the son with a sum that represented the extent to which the value of the farm increased as a result of his contribution, or limiting the relief to the grant of a farming business tenancy. And the Court of Appeal dismissed the appeal. An unconscionable result would normally appear to be so to an objective bystander. However, the bystander had to consider all the circumstances, including the expectations of the son and the detriment to him. It did not consider this solely through the eyes of the parents, and so the parents' case on this was not supported by authority. The judge had found that there had been a clear assurance given to the son that he would inherit a sufficient interest in the farm to enable him to farm there. His expectation was a strong factor in deciding how to satisfy the equity. The parties could not continue to work and live together in close proximity, so the intention for him to inherit on the death of the parents could not be implemented by way of a deferral. The sale was an unfortunate consequence of the breakdown in relations and as part of what was necessary to avoid an unconscionable outcome. And so this was ultimately appealed to the Supreme Court. And the appeal raised two particular questions. So firstly, whether a successful claimant's expectation, in this case of inheritance of a family farm, was an appropriate starting point when considering a remedy. And secondly, whether the remedy granted, namely payment of a lump sum which would in effect result in the sale of the farm, went beyond what was necessary in the circumstances. Now, somewhat unhelpfully, this was heard in December 2021, and we are yet to receive a judgment from the Supreme Court, so everyone is waiting to see what happens with that. There is another case that you will want to have a look at, which is Hughes and Pritchard. Now, at the moment, that has been referred down to the High Court for a determination on, surprise, surprise, the issues of detriment and remedy in proprietary estoppel, and I imagine that that's being held back until the Supreme Court gives its judgment on guest and guest. As to when that will happen, we have no idea. You generally expect that it's dealt with within about 9 months. It's been past that now, so we'll see, hopefully soon. But hopefully what we'll get from the Supreme Court is a decision that will actually bring clarity to this issue of what the starting position is in relation to remedies. Now, realistically, when you're pleading your cases, should you plead constructive trust or proprietary estoppel? Most of the time, if you have enough to be able to argue a proprietary estoppel claim, you can generally argue that there'll be a common intention constructive trust, but it's not necessarily the case that if you can argue common intention constructive trust, that you'll be able to argue proprietary estoppel. The advantage of a constructive trust claim is it allows you more certainty as to the remedy. So if your client is particularly keen on obtaining a specific share in the property, constructive trust is what you're going to want to put forward as your primary argument, because the court has such wide discretion on a proprietary estoppel claim that even if you're saying, look, there was a promise that I would receive a 60% interest or an 80% interest, they may well receive a far smaller interest, they may well receive a lump sum. Insofar as the costs are concerned, it shouldn't really increase the cost massively to be arguing proprietary estoppel as your alternative. It may make a difference insofar as the court that you decide to issue in is concerned. But I'd say that ultimately the main reason that people tend to pick one or over the other insofar as how they're pleaded or the structure in which they put them forward as to which is their alternative tends to be how keen they are on receiving a particular remedy and the level of certainty that they want in that respect. So hopefully that has been helpful. I will now hand you back over to Leslie.
Thank you very much, Natasha. Would help find music before I actually started saying anything. Right, I'm going to talk about the topic of varying agreements. By that I mean agreements in respect to the sale of land by estoppel. You don't have the notes, so you have the pleasure of looking at me while I'm talking. But the notes that I'm reading from will be available and will be distributed after the talk. So there are 3 questions I'm going to be asking. Firstly, I'm going to say, can you rely on estoppels to avoid the effect of Section 2 of the Law of Property Miscellaneous Provisions Act? Second, what estoppels can you rely on, if you can, and when can you do it? And I'm going to look in particular at the recent judgment of Mr. Justice Snowden of Howe and Gossip, which is the latest word on the topic. Secondly, I'm going to ask whether you can rely on estoppels to vary contracts for the sale of land. And my third question is going to be what estoppels might be effective to vary contracts in the light of the Supreme Court's decision of Rock Advertising against NWB, which isn't a sale of land point, but raises issues concerning estoppels. So, as I'm sure you will know, Section 2 of the Law of Property Miscellaneous Provisions Act 1989 provides that a contract for the sale or other disposition of an interest in land can only be made in writing and only by incorporating all the terms which the parties have expressly agreed in one document, or where the contracts are exchanged in each. That's the requirement, that's the gatekeeping specification. If you don't have that, you don't have a contract. But there is an exception, Section 2, subsection 5. Nothing in this section affects the creation of or operation of resulting, implied, or constructive trusts. And the courts have spent a lot of time scratching their head and saying, well, that's what it says, but it doesn't say anything about estoppels. Some judges have said, well, estoppels are like constructive trusts, as we heard from Natasha, or they work in this particular way. The answer seems to me to be rather simpler, that an estoppel is a remedial doctrine, whereas a trust actually creates and is an interest in land. So that's why estoppels, and in particular proprietary estoppels, haven't been mentioned. In most cases, estoppels as a doctrine are based on reliance. There are some estoppels that aren't, but most of them that we're dealing with are. And before the 1989 Act was passed, there was another reliance-based doctrine which was effective in this area, and that's the doctrine of par performance. Basically, that related to what used to be Section 4 of the Statute of Frauds, 1677, or later Section 40 of the Law of Property Act 1925, which said that unless a contract for the sale of land was evidenced in signed writing, you couldn't enforce it. So it's a bit less strict than Section 2. But the doctrine of par performance said that if an act that was referable to the contract had been carried out, then you could nonetheless rely on the contract even if it was oral. That doctrine of par performance has definitely been abolished indirectly by Section 2. There's a decision to that effect in the Court of Appeal in 2014 called Natter Lee against Abid. So reliance on the terms of an informal contract, which would have been par performance, you might think is not sufficient to get past the effect of Section 2 nowadays. When we're looking at these principles, it's worth bearing in mind that the courts have been pulled in two different directions. On the one hand, you've got the policy imperative that if Parliament says you don't have a contract in these circumstances, that's the end of the matter. Lord Scott in Cobb and Yeoman's Row in 2008 said that his view was that proprietary estoppel could not be prayed in aid in order to render enforceable an agreement that statute has declared to be void. On the other hand, we've had very recently, this is Justice Fogg in Sahota and Pryor in 2019, making the point that what's been made void is the agreement for the sale or other disposition of land, nothing else. So she makes the point that if you can rely on another doctrine, well, Section 2 doesn't say anything about it. So those being the sort of battle lines that have been drawn, what sort of estoppels work here? What do you have to make out if you're nonetheless going to get a remedy, even though your contract is informal? Well, one possibility would be promissory estoppel. Two problems with that. First of all, promissory estoppel is a shield, not a sword, so it doesn't found a cause of action. And secondly, we've got Lord Justice Lewis saying this in Dudley Muslim Association against Dudley Metropolitan Borough Council in 2016, that it would be surprising if one could do by promissory estoppel what one could not do by informal contract. So no approval there. Second possibility is estoppel by convention, where the parties conduct themselves on the basis that there is a valid binding contract between themselves, such that each of them is precluded from denying the existence of that contract. But since 1997, and a decision of the Court of Appeal called Godden against Merthyr Tydfil Housing Association, that's not been an available way forward. There, Lord Justice Simon Brown said that the submission was clear enough, but it necessarily involved saying that although Parliament has dictated that a contract involving the disposition of land made otherwise in compliance with Section 2 is void, the defendants are not allowed to say so. That, to my mind, is an impossible argument. Well, I think that's a bit broad, and we'll come back to whether it's impossible at the end of this talk, but that's his view. So no, on present safety law, no estoppel by convention to create informal agreements of this sort. Now, as Natasha rightly pointed out, there has been a whole swathe of authorities where parties have sought to enforce informal agreements by reason of the doctrine of proprietary estoppel. And one of the questions the courts has never decided, I mean never, is whether Section 2 of the Law of Property Act prevents proprietary estoppel from arising. There have been lots of suggestions, lots of obiter comments, but no actual decision. And there's been a back and forth over whether it can, whether it can't, and what the requirements are to run such an argument successfully. The short answer is that all of those arguments and cases are set out in Emmet on Title, Section 2-30. That's about 12 pages of closely typed analysis and comment. But the main historical takeaways, I think, are these. As I see it, what's been happening is that the court's been moving away from preventing people relying on proprietary estoppel to basically saying, well, you can run it in any case where you're not taking the nick, where you're not suggesting that, yes, it's a contract, but really I've done this sort of thing, so let me have the remedy. So if you look at the way the laws move forward, you probably start off with the Law Commission report before the Act was passed. That simply said, well, estoppels are available in moments of difficulty. That we thought was going to be the way forwards. Yaxley and Gotts, Court of Appeal in 2000, seemed to have any difficulty in awarding a remedy based on proprietary estoppel, citing the Law Commission report. But then we had the roadblock that is Cobb against Yeoman's Row in 2008, where Lord Scott, joined by 4 other members of the House of Lords, said, no, you can't do it. I've got some doubts as to his technical analysis, but nonetheless, that's what he said. So how could one get around it? Well, the House of Lords got around it by ignoring it, really, in the first stage. In Thorner and Major, that was basically an informal agreement to leave a farm by inheritance. And the House of Lords didn't really have any difficulty in saying, well, yes, you can have an estoppel here, and it's a proprietary estoppel, and then awarding the farm, doing the very thing that had been promised. And yes, that wasn't a contract, it was clearly not a contract, it was something else, but nonetheless it did what a contract would have done. It was a promissory representation. So how does the court square the circle? Well, Herbert and Doyle is probably the next stop in 2010. And Lady Justice Ard described Cobb and Yeoman's Row as being a case, the golden thread that was running through it was that it was a case that related to an incomplete contract where the parties at all times intended to go on and have a proper contract. It was a so-called gentleman's agreement. And she said, well, if you don't have that sort of case, if you have a case where the property is clearly identified, the parties expect their agreement to be immediately binding, in those circumstances, you could have had a constructive trust. And we see that section 2, subsection 5 permits that. And so therefore, equally, you can have a proprietary estoppel. So that is basically saying that proprietary estoppels run in the case of genuine informal agreements, where the parties don't think about formalities, but simply proceed on the basis that they are immediately bound. I would make one point about proprietary estoppels I think gets a bit overlooked, and that is that you can only rely on it if you're the party who is seeking to claim or get the interest in land. You can't rely on a proprietary estoppel to sell property, you only rely on proprietary estoppel to get it. Second point is that, I say you can't rely on proprietary estoppel to sell property. Almost all the proprietary estoppel cases are cases where they're essentially transaction, but the transaction is not a stated consideration. So it's the farm is yours, and therefore they work on the farm for their lifetime. Sometimes there are cases where the promise is, if you work on this farm for life, then you can inherit it. And that looks like a unilateral contract. If you do this, I will do Y. But nonetheless, that doesn't seem to be a problem. Indeed, in those sorts of cases, see Jennings and Rice, you're more likely to get what was promised, as Natasha was talking about, than simply get the detriment that you've suffered, if that's less in terms of value than the promise. So the latest word on the topic is Howard Gossip, Mr. Justice Snowden's decision 2021, EWHC 637. And his lordship doubted whether section 2 had any relevance to the application of proprietary estoppel at all. So that seems to be pretty clear. But nonetheless, he said that if it did, it was available where the claimant was not seeking to enforce the terms of the contract. Now, of course, it could be a bit colourable, a bit dodgy. You put forward the estoppel case because really, you can't get through with your binding contract, but pretty wide. He made the point that in that case, the claimant was not claiming the relief open to him under the contract. So he'd entered into an informal agreement. That meant he would have land. He'd then done work on the land, and he said, no, what I want is a right to have the land for life. And that was a difference, said the judge. Well, Emmett thinks that's a bit uncertain, a bit wrong, possibly. And the point, I think, is that, well, if you're claiming under a contract to buy the land, what you might do as a matter of tactics is to say, well, I won't have the land, I'll have a long lease of the land, something slightly different. So you manipulate the remedy you seek in order to avoid the effect of section 2. And Emmett, writing from a purist point of view, thinks that wouldn't be right. And Emmett may be right, but that's something to bear in mind. The judge disapproved the suggestion made in McGarry and Wade's Law of Real Property, currently the 9th edition, that the claim has to be an exceptional one to produce a proprietary estoppel in these circumstances. Says no, that wasn't right, unsupported by authority. And he also said, and this links up with the par performance point, that there had to be an additional representation besides the failed contract. So it wasn't enough that a party thought he'd bought something and then relied on it. There had to be a separate statement from the vendor that the title was going to pass or had passed or repassed or something to that effect that he could rely on. He did make the point that simply because one party relies on section 2, that's not going to satisfy the unconscionability requirement for a proprietary estoppel claim. And as I'm sure we know, you don't get anywhere in proprietary estoppel unless your circumstances render it unconscionable for the other party to go back on his promise. So unconscionability has to be there. It can't simply be that somebody's refusing to transfer you the land under the terms of an informal contract. It has to be something else, some commitment or reliance. So that's the position as it presently exists with the creation of interests in land under proprietary estoppel in a very short nutshell. But this talk is headed varying agreements by estoppel. So let's look first of all at the question of variation. What happens if you have a binding agreement, it's all in writing, it's all signed, and then informally someone tries to vary the terms? Now, the first thing to say is that the sort of estoppels we're going to be looking at here are going to be normally promissory estoppels or estoppel by convention, because those are the sorts of estoppels that generally do affect contract terms. If the promise that's been made or the representation that's been made subsequent to our contract, our binding contract, creates a separate interest in the land, then of course a proprietary estoppel might run. So if somebody's given a right of way over land, and a little while later, the owner of the land says, oh, well, you know it's yours, knowing that they use it all the time for passing backwards and forwards over it, and the representee relies on that. Well, in those circumstances, the fact that there's an informal and unenforceable contract for a lesser interest is going to be irrelevant. So what's the basic principle? Well, the basic principles are these. The first one is that Section 2 applies just as much to variations as it does to the initial contract. And that was decided in 1997, a case called McCausland against Duncan Lorry. Now, in that case, the Court of Appeal, it really was an important issue as to whether the variation was effective, because the circumstances were that contract for sale of land, completion was actually due on a Sunday. The parties said, well, this is stupid. We'll agree to have completion on the Friday. The Friday came, there was no completion, and the vendors served a notice to complete on the Friday. And that's only a valid notice to complete if that was the date for contractual completion. The notice expired, and the purchaser then said, well, actually, I will buy the land, here's the money, and started an action for specific performance. The vendor said, no, I brought the contract to an end, that's my defence. Went to the Court of Appeal on striker on the issue of variation. And the Court of Appeal said, no, to be a valid variation, that had to be in writing and signed. It wasn't. Therefore, the notice to complete was invalid. Therefore, specific performance is at least potentially available as a remedy because the contract still exists. What they, however, said was this, because it was also argued in the alternative, that there was an estoppel which prevented the vendor prevented the purchaser, right, from arguing that the date was as per the contract. Lord Justice Neal said, I've indicated earlier in this judgment the nature of the estoppel on which the bank would seek to rely. I am satisfied, however, that this issue cannot be resolved without evidence. I propose to say nothing further about it, save that I consider that the point is plainly arguable. And Lord Justice Moritz said this, Section 2 of the Act of 1989 does not give rise to any illegality if its terms are not observed. The need for an estoppel arises in just those circumstances where there is no enforceable contract. For my part, I would not place weight on the contention that an estoppel such as the vendor would advance is impossible as a matter of law, but it still has to be made out as a matter of fact. Well, Lord Justice Morris and Lord Justice Neal, clearly thinking that it was an arguable case. They remitted it to the judge. Now, bear in mind also that it was a claim for specific performance, and if the facts for an estoppel were laid out, the court might have refused specific performance, even though a proprietary some form of estoppel could not have been put forward specifically as a doctrine in equity. So, an open question. That open question has, on the one hand, been open a little more, on the other hand, been shut. Open a little more by Mr. Justice Nugent, there was in Kemp and Bullen, which is an immensely complicated case, which turned on whether parties could agree orally a variation to an option agreement or not. And he said that, well, this was a promissory estoppel, as he held it. And he said that if it were a mere agreement to vary the terms of the contract, seems to me to be a contractual variation, it was bound to fall foul of Section 2. But he said, well, a specific agreement to be bound by the varied terms might be sufficient for an estoppel. So in other words, if one of the parties says, yes, I know that what we're talking about isn't really binding, but let's be bound by it, the parties rely on that, well, in those circumstances, what about it? Might be an argument. But he didn't have to decide it in that case. In the Dudley case, as I've referred to already, Lord Justice Lewison was rather more trenchant. He considered that no claim based on promissory estoppel would succeed. He said this: where a defence is based on promissory estoppel, there is no question of constructive trust of land arising. And in the circumstances of this case, where the association already owned the land, there is no relevant property which is capable of being held on trust for the association. Unless the case falls within Section 2, subsection 5, to admit a defence based on promissory estoppel would be effectively to repeal the section by judicial legislation. Now, in the context of a variation, which is what this was, argued, as that strikes me as being a little bit over the top. But nonetheless, it seems to be clear, at least dicta, to the effect that you can't rely on a variation and estoppel if you're trying to vary a binding contract. Now, this brings me on to my third point, which is rock advertising and NWB, and I'll go through this perhaps more quickly than I otherwise would have done in view of the time. It was a case concerning a contract, a license contract, which was written and formal, and which included what was called a no-all modification clause, where the parties agreed that no variation of this agreement will be effective unless it's signed by both parties and in writing. One of the parties said, well, subsequently we had an oral conversation where we agreed to vary it. And the question was, is that a valid argument, bearing in mind the no-all modification clause? And the Court of Appeal said, yes, it is. If you can bind yourself on the one hand, you can unbind yourself with the other. The Supreme Court said, no, it wasn't. That's material from our point of view. Because in effect, the Supreme Court said, well, the parties are creating their own little law of formality. And once they create it, they cannot uncreate it, unless, of course, they both agree to vary the contract. The one thing you can't do, said Lord Sumption, in those circumstances, is say, well, the parties have agreed to do it informally because they bound themselves to do it only formally. He did say at paragraph 16, and this is what's material from our point of view, that in some legal systems, that is the ability to vary these agreements, this result would follow from concepts of contractual good faith or abuse of rights. In England, the safeguard against injustice lies in the various doctrines of estoppel. This is not the place to explore the circumstances in which a person can be estopped from relying on a contractual provision, laying down conditions for the formal validity of a variation. And he went on to require first that there would have to be some words or conduct unequivocally representing that the variation was valid, notwithstanding its informality. So I really mean it, this is going to be binding. And secondly, something more would be required for this purpose than the informal promise itself, so some genuine reliance outside of the promise. The question for us is, how does that square with cases such as Dudley? My suggestion is that an estoppel would be effective because it's essentially a rule of practice. If somebody has bound themselves not to assert that a document was not signed, or that an informal agreement is not valid and binding, notwithstanding the absence of formalities, then that's how estoppel works. They cannot plead it. And it seems to me that in the appropriate case, any judge would come to that conclusion. I appreciate maybe going against what was said 25 years ago by Lord Justice Simon Brown in Godden and Merthyr Tydfil. I think that the words of Lord Sunshine in Rock and MWB means that that would be a good argument. So more the chicken light for estoppel, and no doubt more cases for lawyers to argue. Well, thank you very much. A little bit over the half hour. I apologise for straining the time. I don't know whether, Natasha, you can come back on the screen. I'm not sure whether I can see whether we have any questions or not. Maybe that everyone is so blown away by what we've said that there's absolute silence. But can you see anything on your screen, Natasha?
There's nothing in the Q&A, so I think we're safe from questions today.
Okay. All right. Well, in that case, I think as we've taken off a bit more of the time that we said we would just thank you all for attending and listening to what we have to say. As I say, my notes will be sent out shortly, and you've got Natasha's. Thank you very much, and may all your estoppels be successful ones and give you the expectation that you're no doubt looking forward to. Thanks very much. Cheerio.